Good morning, friends. Appeal under Section 38 of the Advocate Act 1961. I am talking about Order 23. An appeal from an order made by the Disciplinary Committee of the Bar Council of India under Section 36 or Section 37 of the Advocate Act 1961 shall be lodged in the court by the aggrieved person or by the Attorney General for India or by the Advocate General of the state concerned, as the case may be, within 60 days from the date on which the order complained of was communicated to the aggrieved person, provided that in computing the period of 60 days, the time required for obtaining an authenticated copy of the order sought to be appealed from shall be excluded. The memorandum of appeal shall be in the form of petition. It shall state succinctly and clearly all the relevant facts leading up to the order complained of, and shall set forth in brief the objections to the decision appealed from and the ground relied on in support of the appeal. The petitioner shall also state the date on which the order complained of was received by the appellant. The allegations, if facts contained in the petition which cannot be verified by reference to the duly authenticated copies of the documents accompanying it, shall be supported by affidavit of the appellant. The petition shall be divided into paragraphs numbered consequently, each paragraph being confined to the distinct portion of the subject, and shall be typed or photocopied or printed on one side of the standard petition paper, demi-full-scale size, or on paper of equally superior quality. The petition shall be made on a court fee stamp of the value of 5,000 rupees and shall be signed by the appellant, where the appellant appears in person or by a duly authorized advocate on record on his behalf. The petition of appeal shall be accompanied by an authenticated copy of the decision, one spare set of the petition and of the accompanying papers at the time of filing, and when the matter is refiled after removing the defects, the advocate on record or the parties appearing in person shall submit at least 3 sets of paper books along with set of the original paper with the declaration that the paper books are complete in all respects. The registrar, after satisfying himself that the petition of appeal is in order, shall endorse thereon the date of presentation, register the same as an appeal, and send a copy thereof to the Secretary, Bar Council of India for record. On the registration of the petition of appeal, the registrar shall, after notice to the appellant or his advocate on record, post the appeal before the court for preliminary hearing and for order as to the issue of notice. Upon the hearing, the court, if satisfied that no prima facie case had been made out for its interference, may dismiss the appeal and or if not so satisfied, direct the notice of appeal be issued to the Advocate General of the state concerned or to the Attorney General for India or to both or and to the respondent. Within 10 days of receipt by him of the intimation of admission of appeal, the Secretary of the Bar Council of India shall transmit to the court the entire original record relating to the case and such a number of copies of the paper books prepared for the use of Disciplinary Committee of the Bar Council of India as may be available. provided that the original record shall not be transmitted to this court unless specifically requested by the court. Within 15 days of the service of notice of admission of the appeal, Advocate General of the state or Attorney General or the respondent may cause an appearance to be entered either personally or by through an advocate on record. Where the respondent does not enter appearance within the time limited, the appeal shall be set down for hearing ex parte as against him on the expiry of period of 1 month from the receipt by him of the notice of admission of appeal. After the receipt of original record, the registrar shall, with all convenient speed, in consultation with the party to the appeal, select the document necessary and relevant for determining the appeal and cause sufficient number of copies of the said record to be typed or photocopied or printed at the expenses of the appellant. Unless otherwise ordered by the court, every appeal under this order shall be made ready and, if possible, posted for hearing before the court within 4 months of the registration thereof. Where the appellant fails to take any step in the appeal within the time fixed for the purpose by these rules or unduly delays in bringing the appeal to the hearing, the registrar shall call upon to explain his default, and if no explanation is offered, or if the explanation offered is, in the opinion of registrar, insufficient, the registrar may, after notifying all the parties who have entered appearance, place the appeal before the court for order on the default, and the court may dismiss the appeal for want of prosecution or give such direction in the matter as it think fit and proper. As far as costs are concerned, the cost of and incidental to all proceedings in the appeal shall be in the discretion of the court. This is all about this order. Thank you for watching. God bless you all.